through these 6 traps to avoid, and I've got 6-ish helpful tips to get you there. But before we do, a bit of housekeeping stuff. As you all know, the Delta variant is currently sweeping across the land. We're not out of the woods yet as far as COVID-19. The mask mandate here in New Mexico is reinstated, and who knows where we're going from here. As important now as it ever was to maintain a COVID-safe workplace. There's a lot of resources here on this slide for you small businesses, especially to access, to get some information from, to be able to maintain a COVID-safe workplace that's compliant with the latest regulations and advice. So be sure to check all that out so that you can do your part and we can get past this thing finally, eventually, hopefully. There's 6 traps I'm going to cover here, and obviously there's as many or as few as you want based on how you broaden or narrow these categories. But the general idea is there's these 6 that I see time and again with my own clients. To give you a bit of background, I'm a business and tax attorney and consultant. I work with clients, small and mid-sized businesses in various life cycles of the business. So starting up, growing, growth cycles, bringing on investors, selling, retiring, liquidation, shutting down, you name it. And so these 6 traps are things that I really commonly see, that it's so helpful to know these in advance and avoid them. Because if you're trying to fix a problem after it's already become a problem, results are going to be mixed at best. But if you can avoid the problem altogether, that's obviously better. So the first one we're going to jump into is misusing LLCs or corporations. Just a general primer, these are business entities that protect their owners from personal liability for the debts and obligations of the businesses, if the businesses are properly set up and operated. And so this means a few things. First, you need to set them up before you start the business. I mean, obviously, if you're a sole proprietor, you can start an LLC at any time, but they're not going to protect you from liability for things you did before you started the LLC. So you want to set them up proactively before you start doing business. And I'm going to cover a few different things that can lead to what's called piercing the corporate veil, which I'll explain in a minute. I'm sure a bunch of you have heard that term thrown about, but some things that you really need to avoid when you're using an LLC or a corporation. They're practically interchangeable for this purpose. You can't use the company's bank account for personal expenses. Don't pay your Netflix out of the company account. Don't pay your mortgage, et cetera, et cetera. The company's bank account needs to be used specifically for the income and expenses of the business. Vice versa, you really don't want to be using your personal bank account to cash checks that were written to the business or to pay expenses of the business. Doing any of this is what is commonly called commingling assets. And if you do that, someone sues the LLC and they get a judgment against the LLC, and the LLC has no money, it's defunct, and they go to the court and say, Your Honor, I want to go after the owner of that LLC to satisfy this judgment. The court's going to look at the way you were running that LLC. And if they see, for example, that you're commingling the assets, they're going to say, okay, the owner clearly wasn't treating this LLC as something separate from them. They're treating it as just an extension of their person. So fair is fair. I'm going to let this person go after the owner of the LLC. It's such a common trap that people fall into. They think, oh, it doesn't matter. It's my LLC. I own it completely. What's the harm in paying my personal stuff out of the LLC's bank account? The harm is you lose the limited liability protections. So really, really, really encourage you not to do that. The next thing, using the company for unrelated business or personal activities. And I'll give you an example of this. Let's say you're one person. You start an LLC that you're not even sure what you're going to do with, but then you run an online business selling various products, let's say cosmetics. You're selling them through your LLC online. But then let's say you also have this great opportunity to buy into a local restaurant chain. And so you use the same LLC for that. You're using this LLC for very unrelated things, with the only commonality being you. The court's going to look at that and say, okay, this LLC is just an extension of their person because it doesn't really exist for any one set purpose. It's just doing whatever the owner wants. It's called the alter ego or instrumentality rule. And if the court finds that your LLC is just your alter ego, they will hold you personally responsible for the debts and obligations of that LLC. So don't do that. And then these next two, I'm going to go over both at the same time because they actually both fall under this theory of what's called undercapitalization. Basically, if you have regular monthly expenses or debts that are coming up and are due and payable, maybe you've got a balloon payment or something, and you deliberately run the LLC's bank account dry by taking out as distributions or draws everything that's in the bank account. And so the bank account is empty. There's nothing for the creditors, for the people you pay regular expenses to, the landlords to go after, because you just empty the bank account. That is a deliberate form of undercapitalization. You have undercapitalized the LLC intentionally. And so the court's going to look at that and say, fair is fair, you can go after the owner. That's one form of undercapitalization, but another one that really slips by people. If you are operating a business that's public facing, that provides services, that maybe has a physical location, a storefront or whatever, that can create a potential reasonably foreseeable risk of harm. And an example of this is you run a retail store, you're mopping the floors, whatever, someone slips and falls. And if you don't have insurance that would cover yourself in that kind of eventuality, and you don't have enough money in your bank account to really cover it, that's another form of undercapitalization under a more liberal interpretation of the law. If you don't have the insurance that could cover such a claim, you don't have any other money, same thing, the court might look at that and say, fair is fair, you can go after the owner. So one piece of advice I give business owners every single time I have a consultation with these topics in mind is have good insurance that is applicable to what your business does and the risks it can potentially incur. So if you've got that commercial storefront, have some commercial liability insurance. If you're providing services like accounting services, maybe errors and omissions insurance. If you're a lawyer, malpractice, which is just a form of E&O, have insurance that's suited to your business, because failure to do so could be seen as undercapitalization, misusing LLCs in a nutshell. A lot of people just assume that, oh, I've got this LLC, that's all I need. It's going to protect me. I don't need anything else. I don't need insurance. I don't really need to take care of how I run the LLC. I have it, and that's enough. And that is just so far from the truth. And so that is the first trap I wanted to point out to you all and make sure that you avoid. The second, and this is the bulk, I want to say the vast majority of the dispute resolution cases that I take on personally are over lease agreements. Don't sign leases that lock you down. You're starting a business, or maybe you've got a business, you're in a growth cycle, and maybe it's time to stop working from home and start working in a commercial space. So you think, okay, I'm going to go lease property. So you're going to lease property, and under the right circumstances, that can help you grow your business. You need space for adding employees, for having customers visit you. Leasing property isn't necessarily a death trap, but leasing property under the wrong circumstances can tie a business down in very untenable situations, can bleed that business dry, can set it up for failure, and then can drag the owner down with the business. And I'm going to cover that a little bit later in personal guarantees. A bad lease agreement can sink a business owner. The question is, what type of good insurance do you advise for international trade? And that's actually a really good question I don't have an easy answer to. I would assume that's some subset of errors and omissions insurance, but I'm not a licensed insurance broker. And so what I usually tell my clients is, okay, you've got a general sense of what your business does. We've chatted about this. We've figured out kind of the contours of what it does. Now go talk to an insurance broker. Talk to someone who's licensed and qualified to advise you on the different types of insurance your business will need. And then get a second opinion if you want, but then go with that. And that's what I'd recommend here. But leasing property in the wrong circumstances, let's have a look at what this looks like. So most commercial leases, they're for a term of 3 to 5 years. Some are longer, some can last 5 to 10 years. Some leases can last 5 to 10 years or more. I've seen leases for 20 years. I saw one lease for 99 years. I'm pretty sure the United States leased property from Cuba under a 99-year lease. That's a whole nother thing. But apart from leases entered into by the government, I have never in my own practice seen a 99-year lease. I know that there are some uses for them. There's perpetual land leases and things like that. But bottom line, for your small business, you should be thinking about the next 3 to 5 years for growth, not 5 to 10, not 10 to 20, not 20 to 30, 3 to 5. You should be focusing on blocks of that size. Obviously, if you're already past that phase where you've grown, you're very well established, maybe you're at the point where you're already franchising and you have a better sense of your needs and your growth, maybe you can sign longer leases. But I want you to really think about this when you sign a commercial lease. Don't fall into the trap of accepting whatever term the landlord is insisting is standard, because every lease out there is negotiable, every single one. If they tell you it's not negotiable, you can find another property where the lease is negotiable. We're not in desert of commercial properties. There's quite a few that are up for rent right now. I just checked the listings earlier today. Don't feel like you have to go with the first option. Some other things to consider: many leases are triple net leases, meaning you're paying base rent plus the lessor's property taxes, property insurance, and what's called common area maintenance fees. If you're in a strip mall or a complex with a common area, which includes parking lots, seating areas, maybe some landscaped areas, in a triple net lease, you're paying all of that. You're paying the base rent, you're paying your respective share of the landlord's property taxes, the landlord's property insurance, in addition to your own renter's insurance. They're not the same thing. You're paying the landlord's insurance and you'll separately have to buy your own insurance. And then you're also paying common area maintenance fees. If you're looking at a lease and it says triple net, understand that's what it means, and understand that you're going to be able to know the base rent in that lease, but the other stuff, it's always going to be estimates. The landlord can give you an estimate of their property taxes, of their property insurance, and the other fees, but you're opening yourself up to variable costs that really can vary, especially when we're talking about maintenance, common area maintenance or maintenance of the building's HVAC or roof. If the lease provides that you as the lessee are paying some share of that, just know that your payments can be wildly variable. So that's a trap to look out for. And if you're not comfortable with that, find a lease that isn't triple net. They are out there. Lots of commercial leases are not triple net. Maybe you can negotiate one with the landlord in exchange for a higher base rent. Be aware of what you're walking into with these leases. And then most leases for new businesses require the owners to sign a personal guarantee by which the owner is committing to pay the entire amount of the lease plus collection costs and other fees if the tenant defaults. There's reasons for that. If you start a brand new LLC, there's a substantial risk that you never really get it off the ground. And so the landlord wants some protection, but just know that those personal guarantees are an onerous thing and they're very common in commercial leases. So this goes back to some other points I was making. Don't sign a lease for an extremely long term, because if you're going to personally guarantee a lease for a business that may or may not make it, you want that lease term to be as short as possible. So that way, if the business goes under and you're obligated for the whole rest of the lease term, you don't want to be obligated for 20 more years of a lease. I mean, obviously the landlord has to relet it and so on and so forth, but minimize your potential exposure by having a shorter lease term. There's a flip side to that, which is that the landlord could raise rent after the term. They could give you the boot, they could sell the property, but it's a risk you'll have to balance with the risk of personal exposure. Another thing to consider here: most commercial leases do not allow the lessee to break the lease early under any circumstances without the approval of the lessor. That should say without, but the idea is the lessor, the landlord, has to approve if you want to break the lease early, and there are typically never going to do that unless you're on very good personal terms with them. Many leases do not allow the lessee to sublet or assign the lease to someone else. So your commercial lease, the landlord might say, you're stuck with it. We're not going to let you find someone else to stand in your place. We're just going to go after you for damages if your business goes under. Many leases grant to the lessor a landlord's lien in whatever assets are kept in the premises. What that means is, if you've got all your business assets, your computers, furniture, fixtures, whatever in the property, and then you default on the lease, the landlord has the right to take and seize that property and put it towards whatever rent you still owe under the term. I say all this, and then I'm underlining this point to drive it home. And I'm not bashing commercial landlords here, but this is just a basic fact. Many commercial leases have terms that would be considered predatory or unconscionable in consumer contexts. For consumer leases, for residential leases, there's an entire section of New Mexico law that's dedicated to tenant protections that govern what a landlord can and cannot do, what they cannot put in the lease. They give tenant rights. That's for residential properties. And one of the biggest mistakes I see people make is thinking that I have that same protection when I lease a commercial space. You do not. Those statutes apply very specifically to residential leases. There's still a thing called unconscionability even in commercial leases, but it's very hard to prove that your commercial lease is unconscionable. And most courts will just defer to the lease and say, you signed it, you're a business, you should have bargaining power, you could have hired a lawyer to look at your lease, so we're holding you responsible for it. So just know that commercial leases are one of the biggest traps, and they are one of the biggest reasons many businesses fail, is because if you're a brand new business, you've got fluctuating income, your income's going to go up, it's going to go down, but leases the landlord's going to expect to get paid what they're owed on time every time without fail. They're not typically sympathetic to you saying it's a slow month, but next month will be faster. And once the landlord initiates default proceedings, it sets off a chain reaction that can really sink a business. You know, if you have questions about this, if you have questions about your lease that you're considering or that you've already signed, use your resources, hire a lawyer, reach out to the SBDC for some guidance or for them to point you in the right direction, but really don't sign these without thinking about it. Some other things that you might do before you sign a lease. Look at the past history of the building that you're about to rent and the businesses that occupied it. And here's a great example. If you are renting a space to start a new restaurant, and that space had 5 restaurants that all failed within a year, maybe it's the space, maybe it's it could be something as innocuous as not enough parking or really difficult to access from the road. Maybe you can't make left turns into the parking lot. Maybe you can't even see it properly from the road. Maybe there's some restriction on signage. But if you're about to rent a building that has had a string of failures before it, that should be a red flag to you. And so you really need to make sure that you're covering your bases and that you have a good exit strategy with that lease. Personal guarantees, again, they're typically required when you're signing a lease with a brand new LLC. But one negotiating tactic I've taken that has had some success is negotiating a personal guarantee that expires after a certain period of time, whether that's 1 year, 2 years, 3 years, whatever. Having a personal guarantee that expires gives you some breathing room down the road. Make sure the lease is assignable or can be submitted or subletted. Assigning means someone else is going to take over your responsibility as the tenant. Subletted means you're going to sublease the property to someone else. In an assignment context, whoever takes over your space will pay the landlord directly. In a subletting context, they are subleasing the property from you. They'll pay you, you pay the landlord. Those are 2 options that you can consider. But if the landlord insists on consenting to any proposed assignment or sublease, make sure it's written in there that their consent shall not be unreasonably withheld. 5 very simple words that have a lot of legal meaning, because it means that the landlord can't just arbitrarily say, no, I'm not going to let you do that. They have to have an actual reason for declining it. Another common trap in these leases, be careful not to assume all the repair obligations for the building. A lot of commercial landlords will sneak this in here towards the middle of the document. They'll assume you don't even read that far, but they'll say that the lessee is responsible for keeping the building in good standing and working condition, including everything. They will try and pass off the responsibility for you to replace the roof, the HVAC system, structural elements, exterior plumbing, electrical, you name it. Landlords will try and pawn that off on the tenants. And if you're renting a building for 5 years and then you have to replace the roof, that is something that adds value to that building for 20 years. And so what's going to happen is either you're going to get the boot and the landlord will release the space to someone else, or they'll sell the space because it's got a new roof, or they'll raise your rent after the initial lease term because all of a sudden you're leasing a building with a brand new roof. What a value to you. The roof that you just personally replaced, it inures to the benefit of the landlord. And so one thing that I do in every lease review is I make sure my clients understand and negotiate away when possible these repair obligations, because you don't want to be on the hook to replace something that's going to cost you 20 or 30 grand so that the landlord can benefit. Finally, and I can't emphasize this point enough, don't be afraid to walk away. No deal is better than a bad deal when it comes to these leases, and I cannot stress that enough. Feel free to walk away. There's other properties out there. I had a client who walked away from one last week because they were insisting on everything I just outlined here. They were insisting that my client as the lessee replace the roof, and the roof was in bad need of replacement. The landlord is going to get the full benefit from that roof replacement, and then the landlord is going to pass the added value of the building back onto my client in the form of increased rent. It is nonsense. Don't be afraid to walk away. The next thing we're going to cover here is personal guarantees. As I mentioned, a personal guarantee, it's an agreement to be personally liable for the debts of or obligations of another. That's the long and short of it. You are agreeing to be responsible for someone else's debts in the event that they don't pay. And so you commonly see this with LLCs, especially brand new ones, and especially when you're signing a lease or you're trying to get credit. The business owner is going to have to personally guarantee the debts and obligations of the business. That's true for SBA loans. That's true for, well, most SBA loans. That's true for most commercial leases, bank loans, you name it. So that's what a personal guarantee is. They're pretty unavoidable in a lot of contexts. Like I said, commercial leases, etc. Even though they're often unavoidable, they're avoidable in a lot of other contexts. And if they're unavoidable, you can negotiate to lessen the burden on yourself. And this is really important. Don't just assume, oh, this is in here, it's take it or leave it, there's nothing I can do about it. Maybe that's true. Maybe that's the negotiating position of the landlord or the lender or whatever, but maybe, and in some cases you can, negotiate away the personal guarantee in exchange for higher interest rates, higher down payments or deposits, you name it. There's ways around this if you're creative and you have a good negotiating partner on the other side. If your landlord's willing to negotiate with you, great. And if they're not willing to negotiate, if they're the take it or leave it kind, again, you just have to consider if that's the arrangement you want or if you want to keep shopping, because there's always other commercial properties out there. But really, that's commercial guarantees in a nutshell. There's one other thing that I should mention about personal guarantees, and this is a big misconception that businesses have. Let's say you have that brand new LLC. You sign that commercial lease. You sign a personal guarantee where you're personally going to honor the lease if the LLC fails. And then let's say the LLC fails, and the landlord's going to go after the LLC, and it's going to go after you personally as the guarantor. You could shut the LLC according to state law. You could declare bankruptcy on behalf of the LLC and then shut it according to state law. Either way, though, it's not going to invalidate that personal guarantee. That guarantee will survive the collapse of the LLC. And so I have clients who frequently ask me, how do I get out of this guarantee? And they don't like the answers because it's either negotiated out with some kind of settlement with the landlord or other party, or you can personally declare bankruptcy, because a personal guarantee is a debt obligation in its own right, and it's an obligation of whoever signs the guarantee, which would be you as the business owner. So if the business goes under and then you personally go through bankruptcy, typically a Chapter 7, maybe a Chapter 13, but in any event, if you go the bankruptcy route personally, you can include the guarantee as a debt that could then be discharged in bankruptcy. The trade-off to that is obvious. Your credit is in tatters. If it's a Chapter 7 bankruptcy, you only get to keep so much of your property and belongings. The rest has to go to pay the creditors. So it's not really an option for a lot of people, especially with means testing now, but that is one way to get rid of your personal guarantee. If you are truly underwater and you have no way out, no chance of paying what you've guaranteed, bankruptcy might be an option for you. At that point, I would say consult a bankruptcy attorney, but that's how you get rid of a personal guarantee. A lot of my clients come through the door and they've been operating in their business for a few years, and I find out they have no contracts in place. No contracts with their customers, with their vendors, with their employees, independent contractors, partners, etc. Just they've been operating either on handshake deals or using something that they pulled from the internet that's about half a page long and doesn't really say much of anything, or worse, it says something that they don't really intend to say. And I always get the question, why do I need them? I've never had any problems with my customers, vendors, employees, contractors, partners before. And my job as an attorney, it's not to promise people what's going to happen, because I can't promise you anything. It's possible that you can go 30 years in business without an issue, despite having terrible contracts or even no contracts. You might be lucky. But my job is to kind of provide my clients with some examples of the worst case possible outcomes if they go that route. Let's have a look at what those are. Without a contract for your business that you would have with customers, your customers can, and here's just a few examples, they can refuse to pay you in full or in a manner you consider timely because they dispute what they agreed to pay you or when they agreed to pay you. They can deny that you provide the goods or services in the manner they expected, because if you don't put this down in writing, what you're going to provide and when, it's up to interpretation. It's up to whatever their understanding was, because contracts are about a meeting of the minds. It's about two parties, well, minimum of two parties, coming to an arrangement where they both have an understanding, a mutual understanding of what each party is going to do for the other. And so they can deny that you did what they expected you would do. Even worse, in some cases, they can deny that a contract exists after you've performed under it, because there's no written contract. They can say, well, we didn't really have a meeting of the minds, so there's no contract. Thanks for everything you did, but go away. And then you're left holding the bag and fighting it out in court over what's called quantum meruit, which is a fun Latin term for basically the value of work provided. If you don't have a contract, you at least get to get paid the value of what you did. But those lawsuits typically are so expensive that no one sues under them, because what you'll recover is often a lot less than what you spend on the lawsuit. So you could be left holding the bag after you've performed and the other party decides they're not gonna. They can claim that you breached, and this is a big one that no one, I swear no one knows about. There's these things in the law called implied warranties. Basically, if you sell something, it is implied that you're warrantying what you sell in at least two ways. Merchantability and fitness for a particular purpose. You're warranting that what you're selling them can be sold or resold, as the case may be, or that it's fit for a very specific use case, fitness for a particular purpose. If you have ever signed a purchase agreement, there's like a 90% chance you've seen in big capital letters somewhere in the bottom third of the document, disclaimers, express disclaimers of the implied warranties of merchantability and fitness for a particular purpose. And there's a reason for that. And the reason is these warranties are vague, they're nebulous, and they rack up over time. So the more you sell to more customers, the more implied warranties you have out there that you could be called upon to honor, even though you didn't know you were providing any warranty at all. And some of those warranties, like merchantability, if they turn around and can't resell it in the way that they expect to, they could turn around and hold you liable for that. So have a written agreement with your customers that even it needs to do the bare minimum. It needs to say who's providing what. Party A is providing goods, party B is providing money. They're going to do it on this time frame and in this manner. These implied warranties are disclaimed. This is what the actual warranties are, if any. This state's laws apply. If there's any lawsuit, it has to be brought in this court. The winner gets attorney's fees. This agreement can be signed in one or more parts. It can be delivered electronically. That's fine. There's some basic framework for an agreement that you should have in every customer contract. It doesn't have to be complicated. I've done this as a two-pager, which is basically the front page is the purchase order and the back page is all the terms and conditions. Small print, but it's doable. But having nothing just really opens yourself up to a litany of problems. But then let's look at this in other contexts, because let's say you're hiring independent contractors. If you don't have a real contract, this can get really thorny. And I mean really thorny, because for one, obviously they could claim that you're not paying them what you agreed to. They could also claim that you agreed to hire them as employees, not as independent contractors, especially once tax and rev goes after them for gross receipts tax. Because fun fact, if you're providing services in New Mexico as an independent contractor, tax and rev considers you your own business, and they will charge you gross receipts tax on the revenue you get, even if you're not passing that tax on to your customer. And so if you are hiring independent contractors and they don't pay their gross receipts tax because they don't know about it, and then the state goes after them, one of the most common things that they will do after talking to an unscrupulous lawyer is claim to the Department of Workforce Solutions and the Department of Labor that they were in fact misclassified employees. And so having a good contract spells out the relationship. It says, no, you're not an employee, you're an independent contractor. And it also makes sure that you spell out in the contract all the things that you need to do to keep them independent contractors, because there's a whole set of rules about that. But if you don't have a real contract with them, who knows how that dispute's going to work out in front of a Department of Labor board that is very employee friendly, notoriously so. And so you're protecting yourself with the contract. Again, there's the other basic stuff. You don't want people to be able to sue you in another state or apply another state's laws. You don't want them to be able to create liability for you or your company that would otherwise be assumed by the independent contractor. You want them to be responsible for the work they do. You want them to be responsible for getting insurance to pay, if they do something bad, someone gets hurt, they need their own workers' comp policy, liability policy, etc. That can all be contained within a contract. And so you should have one. Business partners, if you don't have contracts with your business partners, this is another thing we see a lot. They can claim ownership percentages, voting rights, rights to profits or losses above what they're really entitled to. If you don't spell it out on paper, they're going to make a claim if they're unscrupulous for way more than they're entitled to. They can try and hold the business hostage to whatever demands they have that the business do or not do something. They might even try and directly compete with the business if there's nothing in writing saying that they can't. So you should have a contract with them. Vendors, vendors provide the contracts most of the time, but it's still important to have one so that everyone has reasonable expectations of what's going to be delivered, when, for what cost, how the vendor can or cannot increase prices, how they can use proprietary information learned from you, or how they can't really. It's a lot of nitpicky stuff, but it's stuff that you never really think about until someone does something that seems horrible and unjust and unfair and wrong, and you start looking for relief, and then you realize, hey, I have nothing in writing saying they can't do that. And by then it's too late. Be proactive, have good contracts. That's simple tip. Number 5, mismarketing. Marketing, obviously something that you have to do. It's something that every business needs to do, with limited exceptions. If you're surviving solely off of word of mouth, if you're one of the most popular restaurants in town where you really don't need to advertise, or if you're dealing with exclusively government contracts and you really don't need to market yourself, you just need to bid, then maybe this doesn't apply to you as much. But for all other businesses, especially customer-facing businesses, you got to market. And one of the common things that I see with my clients is they're stuck in an early stage of business development because they never hit milestones and never enter into a growth cycle where they can grow and expand because the clientele has never really grown with them. And a lot of that comes down to demand for services, but honestly, more of it comes down to marketing missteps. Your business needs revenue to survive. Revenue comes from customers and clients. They need to know about your business in order to patronize it, and they're not going to learn about your business unless you tell them somehow. And so marketing, good marketing, there's a few basic rules for it. You have a target audience. You don't want to just throw your marketing materials into the wind and hope it carries those materials to someone who has an interest in your business. You should have a sense of who you want to reach with your marketing efforts, because you only have so many ad dollars to spend. You only have so much money to spend on advertising. So you want to use it in the most effective way possible to reach the target audience that's most likely to bring revenue to your business. So you want to know who your audience is. You want to market to that audience, making effective use of your limited resources. Your advertisements should explain what your business does, who you are and what you do. That might sound really self-explanatory, but I swear I've seen some advertisements where I had no idea who was behind the advertisement, what the business was, because they forgot to mention their own name. They forgot to mention what they do. And it's not just about what you do, it's about how you add value. If we're talking marketing to other businesses, your services have to be a value proposition. You have to do something for them better than they can do themselves or cheaper than they can do it themselves. And so your ads should relay that to some degree or generate enough interest in the target audience so that they research your business and then figure out what the value add is. Your marketing strategy should grow your target audience over time, expand your reach, find new sources of revenue. So it should grow and evolve, and it should grow and evolve with the times. Because, and this is another thing, and this is actually a little bit of hilarity. If you read legal rules of professional conduct, for example, they are very geared towards a form of advertising that is rarely, if ever, used anymore. Yellow and white pages and billboards are what those rules primarily regulate. But this is the year of our Lord 2021. We have search engines with business profiles. Not going to name them, but you know what they are. Social media websites, trade publications, review websites, affiliate marketing groups. There's all kinds of ways to market your business now. And a good marketing strategy looks at these all and makes effective use of all of them to varying degrees based on who you're trying to reach. And you really can't neglect the modern advertising mechanisms anymore, because by and large, people aren't, it used to be, white pages and yellow pages. Then it was websites. Then it was finding your websites through social media, search engines. Then it was, finding your business profile that is separately set up on the search engine. Now it's social media presence and finding your social media pages. It's a combination of all of these things, and you can't neglect any of them if you're really trying to maximize your marketing potential. And so tip 5.1, constantly reevaluate and evolve your marketing strategies. And obviously, not everyone's a marketing expert, and you're not expected to be. To the extent you can do your own marketing, great. To the extent you can't, there are people whose sole purpose in the business world is to help other businesses market themselves. There's marketing consultants and firms. Some of them offer very different products and packages, whether on a flat rate or something per month, who knows. But the point is, there's tons of options, but there's this thing called marketing paralysis where you don't know what to do necessarily, and so you do nothing. And that is the worst thing you can do. So take some time, figure out your options, and really take the time to fine tune your presence online and offline. Reach out if you need help. Again, the SBDC is a great resource that can point you in different directions. They're probably not going to do your marketing for you, but they can certainly give you some great counseling, and they can certainly point you in the right direction. They've got a wealth of contacts throughout the state of New Mexico. So maybe reach out to them if you're finding this whole process a little too daunting. They can definitely help get you where you need to go, one way or the other. And then finally, failing to plan for tomorrow or for today. This is something that really sounds daunting for a lot of people, because if you're just starting your business, how do you know what you're going to need tomorrow? You might not even know what you're going to need today. But, and I say this, good businesses are going to plan for the short term. Great businesses are going to plan for the short term and long term, both, because it's not just about what you do today. If you have ambitions down the road to franchise, to expand internally to new locations, to sell the business, to get institutional capital and financing, investors, any of these other things, I mean, you have to really figure out what your ambitions and long-term goals are, and then you plan everything with that in mind, as well as your basic short-term needs. Hey, I need to get up and running. I need customers. I need money. If you can plan for both the short-term and the long-term, you're going to be really well positioned to execute on growth strategies. And so I'll give you a few examples here. There's this thing called qualified small business stock, where if you have a C corporation, not an LLC taxed as one, this is a big thing, a real C corporation, and your stock is worth under a certain amount when you get it, and you hold it for at least 5 years, and it qualifies under the laws, qualified small business stock, you can sell it and write off up to half the capital gains. depending, it's a lot of depending in the tax code, but the point is it can save you tons of tax money over what you might otherwise pay if you didn't go the qualified small business stock route. But that requires that you have a plan in advance to do that. Alternatively, you might go the S Corp route to minimize your Social Security and Medicare self-employment tax burdens, which requires you to look at your expected growth and revenue and really plan out how you're going to do this. If you're going to be taking on capital investors in a few years, you might want to get a head start by having a C Corp because that's what they typically prefer. Same with leases. You have to plan for today and for tomorrow. So don't sign a 10-year lease for a building you're going to outgrow in a year and a half. I have restaurant clients who literally can't grow because they are locked into a very burdensome lease for a space that is way too small to allow any kind of growth. So they're looking at second locations, but they're going to be tied to that first one for years to come. So the point of all this is just be thinking about what you want for this business and where you want to take it in 1 year, in 5 years, in 10 years, in 20 years, if you really want to go that far. But I mean, 10 years is probably a good sweet spot to focus on because in 10 years, you'll obviously want to reassess based on how you've done the preceding decade. But plan for today, plan for tomorrow. The worst thing you can do is fail to plan at all because then you're going in blind. But if you can think of some of these things that you might want to do with the company down the road, it's going to change how you set it up in the beginning. Are you saying a C Corp is preferable to an LLC? There's not an easy answer to that question because it really depends on what you want to do. But I am saying that in almost every case except one, a C Corp is preferable to an LLC taxed as a C Corp. If you want a different kind of taxation, whether that's S Corp, partnership, or disregarded entity, an LLC is probably going to be the best thing for you. But if you want the benefits of C Corp taxation or C Corp ownership, which are just beyond taxation, there's benefits to owning a C Corp, which I've covered in other webinars, and I'm sure I'll cover in a future webinar. But if you want the benefits of a C Corp, you have two options, a real C Corp or an LLC taxed as one. But because a real C Corp can do things an LLC can't, both in terms of qualified small business stock and in preferred shares, Class B shares, et cetera, stuff that investors really like, I'll almost never recommend an LLC over a C Corp. An LLC taxes a C Corp over a real C Corp. So that's somewhat lengthy and rambly answer to that. Can you just switch your LLC to a C Corp at an appropriate time? And the answer is yes, you can, but it is not the easiest thing in the world to do. It's what's called an entity conversion, which New Mexico supports to a very limited degree. There's a lot of moving stuff. You might need a new EIN for the company, which would mean that you need new bank accounts. You might need to sign new contracts at that point. If some contracts don't assign, it's not the easiest thing in the world to convert from an LLC to a corporation. And so this is what I'm talking about when I say plan for tomorrow. If you know you're going to need a C Corp for something in the near-ish to midterm future, maybe you want to just start with a C Corp from the get-go. Or maybe you don't because of the tax implications. It's important to think through these things, is I guess my point. I kind of want to emphasize that you need to use your resources because there's so many great resources at your fingertips. And you have the option, obviously, to use none of them. You can kind of go it alone, walk in blind, but there's so many resources that are free or low cost. I mean, the NMSBDC offers no cost business counseling, loan assistance, et cetera, stuff that I as an attorney don't do. I mean, I just don't offer no cost counseling or consults. And so there's a lot of great resources out there that if you use properly, you're just going to have better outcomes. You're going to think through some issues that might not have been on your radar, and they're going to factor into your planning, which in turn means that you don't have to deal with them reactively as they crop up because you've already planned for them. And so you're going to have better outcomes, which means you're going to be able to grow your business better. Possibly, I mean, nothing's guaranteed in this world, but the point is you're going to have a better shot at it if you use your resources. So I cannot emphasize this enough. Highly recommend checking out what the NMS BDC has to offer in terms of future workshops, no cost business counseling, and so on. It's just great resources that you shouldn't just leave on the table.